disenfranchised enough to the partisan politics going so extreme on both ends, not knowing what to trust by most of the, like most of the country, frankly. Okay. Good morning. It's October 17, 2025 in Carson City Justice Court. This is the second day of continuance of a prelim from yesterday in case number 24 CR 01624, State of Nevada versus James Walter, DeGraffenreid III, Jesse V. Vaughn, Shawn Meehan, Herbert James Hindle, Eileen Rice. Reviewing the courtroom, it looks like we have, I believe everybody, 1, 2, 3, 4, 5, 6.
We got them all. Mr. Law's here for some favor.
Yeah, and that's, that was the end.
Yes.
Individually, I just wanted to triple check my faces. There's a couple similar, not super, but the two bears through me. In any event, all counsel are present. I'm not going to recite the names again. Reviewing the case last night, reviewing the exhibit sheet and the evidence, I noted one anomaly, and perhaps it was how I phrased it or didn't, or it was a mistake. That Exhibit H, the Jack Smith purported report, the offer that under the evidence code was to have it come in against the state. I forget the exact site. If it's some sort of other vetted investigation by some authorized agency. That's not a perfect quote of it. The offer of proof regarding the foundation of it was, this is where it came from, this is what it is. The state had not seen that and had an opportunity to review it. I looked at it, I didn't see the URLs on the bottom. Nonetheless, I was persuaded that it is likely what it purported to be, and I don't know if I misspoke on the record, but at the very end, my clear recollection is that I admitted it, but on the exhibit sheet it shows that it's not. So I did admit that, and then frankly last night, and I'll take evidence from either side on this, I pulled up the Smith report, just simply Googled it, got to the, whatever it was, justice.gov website. It appears to be exactly what it purports to be. So if I miss something, or there's additional argument on that, I did intend to admit it, and I thought I did, and I saw that it was not. So, Ms. Engler?
Based on your ruling from yesterday, we'll submit it.
Okay. So just, it was probably an error, and I know that bailiff tried to go over it with all the parties to make sure we were on the same page, but I caught that. So with that, the state rested yesterday. It's time for the defense's case.
Yes, sir.
And you've got no burden to do or present anything.
Correct, and we are not going to present any evidence. I'm going to make one offer of proof on the cert petition, or ask the court to take judicial notice of a matter that's a public record. And then I want to, just as part of the defense case, I want to once again attempt the admission of 3 defense exhibits that the court has already ruled were not. I just want to, again, try to lay the foundation to make the record, if I may.
Okay, and then because
And
yesterday,
then no other witnesses.
right, and I'm not fully trying to talk you out of that. I'd like to say something that may or may not affect your decision. Yesterday, when the Mueller report was brought up, I admitted it because assuming it's the truth of the proffer, it seemed it fit the exception to the hearsay rule to come in. I made some comments on the record that essentially I didn't have much faith in it. Partisan politics, what they are, it was brought up that, well, this was actually done by someone who theoretically is aligned with one of the parties such that it makes it more credible. I, using some colloquial terms, poo-pooed that inappropriately, essentially prejudging that. I'll explain a little bit of that when we get to a ruling. But it was admitted, and I read last night, not the entire document, but the main pages. They were around pages 10 through 17, something like that in the document. From that, and comparing it to some of the emails, I believe Exhibit 7 that were in, and the other evidence that actually came in, not the proffers, but the evidence that came in, it appears that Mr. Chesbrough is, trying to think how they termed it, confidential, co-conspirator, number 5. If he's not, he's in the exact same position as confidential conspirator number 5, drawing that inference from the contents of the document and the other evidence in the case. So with that, just pre-gaming your position, it appears that what you want to get in is likely meaningfully already in Exhibit H. So I don't know if you wish to continue with that, you're free to.
Yes, just to make the record clear, I was just talking about 3 exhibits. I'm still baffled by the position of the state in objecting to evidence they admitted before the grand jury to indict these 6 people, when the grand jury can only receive competent legal evidence. And state lays the foundation, introduces it before the federal grand jury, indicts these 6 people, and then when I offer it to defend these 6 people, the state objects and wants to keep out the evidence that got them indicted in Clark County. I just still can't get my head around how we can end up with this ruling. So what I would offer for these is the grand jury testimony only of those pages related to the introduction of these exhibits, as under the catch-all hearsay exception. It's the testimony of Mr. Chesbrough before the grand jury introducing the exhibits. And so he's not here. It's his testimony. It's under oath in the grand jury, which resulted in the indictment of these people in Clark County for one of the same offenses we're now here on. So I could produce the pages of his testimony, solely resent, not all of it. I mean, because I understand the court's ruling already on his previous testimony. So I'm just offering it to establish the why it's admissible here.
Thank you. Ms. Engler?
Your Honor, I think we belabored this point in length yesterday. My position still remains the same. The proceedings at grand jury are vastly different than a preliminary hearing. Our burden's different at grand jury. there's reasons that we present things at grand jury that we wouldn't normally present at preliminary hearing because there isn't the ability for cross-examination. So I'll submit it on my arguments yesterday that I don't think that there's a basis in which to get it in, it's hearsay, and I don't believe that there's an exception that applies.
I could just respond.
Yes.
I mean, it's almost, as Ms. McLetchie handed me a note, it's a stopple. I mean, the state can't have it both ways. They vouched for it, offered it, used it as valid evidence to indict the individuals, and now should be stopped from saying it's not admissible.
Your Honor.
Okay, hang on. Okay. So, the exhibits, just so we're clear.
Yeah, it'd be exhibit
Like it's A,
A,
C, and B,
E, and F.
or A?
So what he's proposing today is different than the exhibits. What he's proposing today, correct me if I'm wrong, Mr. Wright, is to present the grand jury transcript. So that would be an entirely different exhibit than what was proffered yesterday.
Right, he's asking for that portion of it so that it could be used to establish a foundation so then he could get into the others.
I wasn't intending to offer all his.
Not the entire thing,
his
but that small
testimony.
portion.
Correct. Only his identification of the exhibits.
Ms. Clerk, can I have the exhibit list?
And Your Honor, just if I can clarify what, because I feel like my words have been getting confused and misinterpreted by defense. Admissibility in proceedings, there are the rules of evidence. Had they brought Mr. Chesbrough in under subpoena, okay, I just want to make sure.
Whether or not they're understanding you, I understand
Thank
each of
you.
your positions. So the exhibits arguably at issue, frankly, from my position of the record, A was not admitted, email chain, I believe it's Mr. DeGraffenreid, likely with Chesbrough. If I considered the grand jury transcript, that small portion of it, or foundation, it might get to something regarding Exhibit A. Then Exhibits C.
No, E.
Okay, so E, the memorandum, and F. I see E.
F is the text message chain.
In that text message chain, my offer of proof again was through who?
That's a text change between Mr. Chesbrough and Mr. Michael Roman.
Okay, so it'd be Mr. Chesbrough's testimony as to the foundation to try and get that text stream. And then E, what's your thought process on E again? Because those two I've never.
E is excuse me, Your Honor, two memorandums were sent by Mr. Chesbrough to the Nevada delegation and the other 5 where there were contests. One memorandum has already been admitted, what we call the December 9. The November 18 memorandum has not been admitted, which was his first memorandum about why this was all above board.
Okay. All right, thank you. So, Exhibit E, still not looked at, it's not in for me. I appreciate counsel's arguments. When we're talking about the catch-all, the assurances of reliability that I have, or hey, they used it before, but where they used it before, kind of like the note that Ms. McLetchie handed you, I was making during your argument before the state made their argument. The proceedings are vastly different. The state has a burden to present exculpatory information. If they don't, that indictment will be subject to a writ and it would be granted. It's that simple. So they have to wear three hats at a grand jury. They have to be a judge, they have to be a prosecutor, and then they essentially have to be a defense attorney, making sure the grand jury has all of the information. It's not an adversarial proceeding. Preliminary hearing's an adversarial proceeding. So it's a new hearing just because it was admitted and used for one purpose in the last hearing. And then most importantly, at that last hearing, the grand jury, there's no cross-examination to flesh out any of the details and motives. So I know that I'm being asked to only look at it regarding foundation. So some of those concerns go away a little bit, but there could be a vast number of questions and doors opened regarding the motives behind the emails, what they meant, who they were for, who they intended to be passed on to, if there were phone calls concomitant with those emails, such that there's different context to what they actually mean despite the words on the page. So when I look at it in that light, I'm not going to go on a catch-all. It's a different purpose. It's a new proceeding. It's adversarial. And then yesterday and today, looking at the former testimony, NRS 51325, arguably it was a ground for me to consider it, but subsection 1 of that requires the declarant to be unavailable. We hashed this out yesterday. He was not subpoenaed, so I don't have that, frankly, as an additional type of ground. Thank you for the record, and it's definitely made in case I've made a legal error.
Yes, sir. The last item was asking the court to take judicial notice that a cert petition from Wisconsin challenge in 2020, filed by Mr. Chesbro, is case number 20-882. That was filed in the United States Supreme Court on December 29th, 2020.
Your Honor, I guess there's two parts. Taking judicial notice is one, and then what is the relevance of that information after the court takes judicial notice? I mean, I haven't had a chance to verify that. You just gave a document. I don't know how to verify it, but my offer of actual relevance is that was a Supreme Court petition based on the conduct and the election in Wisconsin only, to what little information I have on it. I don't know how that bears to what happened here in Nevada, that the fact that some other state filed a petition doesn't have any bearing on the results of the election in Nevada, or does it have any reference to the state of mind of the defendants, which I believe is what the intent of taking judicial notice. So
All I request, I'm not asking the court to take judicial notice of the arguments in the petition, just the fact that it was filed on that date, after Safe Harbor date, prior to January 6th, and after December 14, and doing exactly what was laid out in an exhibit that is in evidence about what you need to do, why you need to vote on December 14th to keep the opportunity for litigation going. And I'm just showing that litigation did occur later, just like could have occurred here. So I'm not asking for the petition or even what the arguments were in it.
And you have a copy showing that it was filed?
I have it on my computer. I can show Ms. Engler. I don't have a
way to print it, but I do have the US Supreme Court website up showing that it was docketed. It was filed, the petition, on December 29th. It was docketed in the US Supreme Court on January 4th, 2021. The petition ultimately was denied on February 22nd, 2021. So obviously well after the safe harbor, when the testimony was that all the litigation has to be completed by the safe harbor. And you can see this is the supremecourt.gov For the state of Nevada, that they're trying to admit actions taken in another state to have relevance here. To me, there's no relevance, so it should be, the court doesn't need to take judicial notice because there's no relevance to that. And Your Honor, the testimony by the state's witness yesterday was that every single state has the same safe harbor deadline. So this shows that litigation related to the election can still be ongoing after the safe harbor dates.
Why let that in when evidence is already in that it can happen regardless of time, but it happened somewhere else later? Does that help prove anything or not prove anything?
It helps show the fact that the litigation was still a possibility at that point, regardless of the safe harbor deadline. Petitions at the US Supreme Court could still have been filed with regard to the,
And regardless of, because the defense is asking me to believe Jack Smith, and regardless of Jack Smith's opinion that the decisions had already been made at a higher level, we're not going to do this. We're going to pivot. So what's the reliability that this filing just theoretically isn't for show in Wisconsin?
Your Honor, one of the attorneys on that particular petition is Kenneth Cheeseborough himself. And the fact is that he's the one who, whether it's co-conspirator number 5 or whomever, that was overseeing all of these things. And he's the one that was advising people, clearly believing and clearly intending that he was going to be filing other further petitions. And he did so. He actually did so in this case after the filing date. And so I think that this is evidence, again, Mr. Cheeseborough showing that he was following through with the plan that he was going through. There was no malicious intent on the part of anybody that they were moving forward with this particularly, and these guys had no reason to believe anything otherwise.
And Your Honor, if I might just add to that, the state's apparent argument is simply that the Supreme Court decision came out before December 14th. And this evidence is relevant to call that into question, Your Honor.
I would note that the other attorney on that is Mr. Trupis, which is a part of the memo as well. So it's the continuation of those individuals.
Given the Jack Smith memo, how I stated in my question back, and the fact that it's not Nevada, frankly, using the balancing test, I can see some marginal relevance, but it's more relevant to Mr. Cheeseborough than these defendants. Those actions post-dated it, and they weren't the actions of these defendants. They post-dated the date in the complaint. And then, again, with Jack Smith's, Cheeseborough and anyone above him, I'd have serious concerns about the credibility of why and what they did in Wisconsin or any other state. I'll deny it. I think the main point is made through the other witnesses, or the other witness with that time frame. It could have happened, frankly. I have no evidence that it did here in Nevada, but that'll be the ruling on that. So back to the defense.
That's it, Your Honor.
Okay. Ms. Engler?
Thank you, Your Honor. So I first just wanted to start by thanking the court, and because the state really appreciates the thoroughness that the court has done through this proceeding. I think you have reviewed all of the evidence, you've taken into consideration all the arguments, so I appreciate that. And with that, I'm not going to belabor a lengthy argument, because I think the court is very familiar with the facts and what the position is of the state. I also know that the court is well aware of what the state's burden is at this proceeding. It's slight or marginal evidence that the defendants have committed the crime of uttering a forged instrument, and the state asserts that it has met that burden. So there's one charge, NRS 205-110, and it says every person who, knowing the same to be forged or altered and with the intent to defraud, shall utter, offer, dispose of, or put off as true, or have in his or her possession with the intent to so utter, offer, dispose of, or put off any forged writing, instrument, or other thing, the false making, forging, or altering of which is punishable as forgery. First, there's no question that the documents offered by the defendants were false at the time of its making, because they were not the duly qualified electors for the state of Nevada. You heard the testimony from Deputy Secretary of State Mark Voloshin, and also contained in Exhibit 13, which is the Supreme Court order. The duly qualified electors for the state of Nevada were the Democratic Party electors, not the defendants. So when you saw on the video where they took an oath and they said, "We are the duly qualified electors for the state of Nevada," that was false. And then they took that statement, they executed it in writing, which you saw in Exhibit 3 and Exhibit 4, where they signed and said they were the duly qualified electors. And that was entirely false. The entire document itself is false. Nowhere at any point were they ruled the duly qualified electors. The defendants intended for the documents to look like the original, because I asked, why would you send them? Why would you send them to all of the 4 places that are required by federal law if you didn't intend for those documents to be received and then used? They wanted to change the outcome of the election. That's why they did it. They created these false documents and they sent them. And that is uttering. Whether a document is genuine combines portions of several documents to create one which is deceptive. Whether you create a replica document, merely possess a document made by another, and attempt to pass it off as genuine, those are all instances of forgery. And here, the entirety of the documents in Exhibit 3 and 4 are false. They created those documents. They altered those documents. You can see in the email, Exhibit 6, they took the documents that were sent to them and they modified them to fit Nevada. Then they signed them and they uttered them. Whether you call it false or forged is really a distinction without a name, because under the definition of forgery, it contains the false making. And I think the court can really feel comfortable setting aside all of the assertions that were made yesterday regarding the quality of the forgery, because you don't have to be a skilled forger to commit forgery. You can have a bad forgery and it still be criminal. So that's not an element of the crime. What Mr. Voloshin thought, what anybody thought about the quality of it, that's not an element, and the court can set those arguments aside. Lastly, the defendants acted with the knowledge that their documents were false. They were all parties to the litigation in Exhibit 13. They knew that the election contest was over, yet they still, 6 days later, stood very publicly, made public statements that were false, and then submitted those documents. I said yesterday, and I know the court's familiar, but I'll just reiterate that at these proceedings, as stated in Patton v. Clark County, which is 92 Nevada 673, where one's in possession of a forged instrument and seeks to pass it, it's permissible to infer for the purposes of establishing probable cause that they acted with the fraudulent intent necessary to commit forgery. And that's where we're at here today. The Nevada Supreme Court, so I submit to the court that the state has presented slight or marginal evidence that the defendants have committed the crime of uttering a forged instrument, and I'd ask that the court appropriately bind this matter over for trial, and I'll reserve my remaining arguments for rebuttal.
So, question for you.
Sure.
Let's set aside the forged nature of the document. In this statute, and when it appeared like I was picking up my phone, I was, because on this bench I don't have the full set of books. In NRS 205-110 that they're charged under, that statute says every person who knowing the same to be forged or altered with the intent to defraud. Who, doesn't say who, shall do these things. Get a false document, put their name on it, essentially adopt the truth of it. But the intent to defraud, can you point more precisely to the facts that you see leaning towards intent to defraud?
Yeah, Your Honor, I think that when they get up there and on video and you watch them, they made these statements calling themselves a duly qualified electors. They planned this, they orchestrated it, and then they submitted it. My position to this court is that the mere fact that they have sent those documents to the correct agencies shows that there was an intent for them to alter the election. That was what their ultimate goal was. They didn't just make a grandstand, sign these documents for the public, and then throw them in the trash. Instead, they went to the post office, they mailed them certified and registered to the agencies that they intended to have them pass. The court can infer that there is an intent to have those documents be received and uttered and taken for consideration. And they didn't use the contingent language. And I know we've talked about other states use contingent language and they weren't told. I think it's important to note that the states that use contingent language, it's because those individuals thought about it. They didn't want to be put in a position where they could face criminal conduct. These defendants didn't question anything. They chose to do this on their own. They are 6 individuals who can think for themselves. And they made a conscious decision to put in writing that they were something that was false. And then they submitted those documents. I submit to the court that that's intent.
Are you asking me to consider that there were other states that put in contingent language? Because my understanding right now, I didn't allow specific documents that have shown that. You can infer some of it through the Jack Smith report.
That's what I'm referring to. The court highlighted the pages that the court read last night, where if you read the footnotes, it talked about the contingent language. And so it appears that from the report that's admitted as exhibits, that some
I just want to make
people-
sure that my decision is based on evidence that was admitted. So,
Right.
Thank you.
So I read those same pages that Your Honor read last night regarding that, and it's clear that other states put contingent language based on that. Again, I haven't seen anything. I don't have copies of those transcripts that they're referring to in there, but.
Okay, thank you.
I don't need help hearing myself. May it please the court, I normally start in any criminal case when I prosecuted them, when I defended them, because I look at the statute and I write out the essential elements that all have to be proven. Here, each by a probable cause standard of evidence. And here, when you take it and pencil it out in the complaint, first element is there must be a forged instrument or document. We contend that that certificate that is identified, the one document identified in the complaint, we contend that is not a forged document within the definition of the statute. Ms. McLetchie is going to argue that point more than I am. The second element is they knew that the document that they signed and possessed was forged. It's forged and they knew it. And the third element was they have to either do something with it to pass it off or possess it with the intent to pass it off. So clearly, there's a document, they knew what the document was, and they did pass it on. And then the fourth element is, in doing all of the other three elements, they must have the intent to defraud as defined in the statute. An intent to defraud means essentially an intention to deceive. The definition in the statute says, through deceit, I am attempting to gain something from someone else. Normally, we all know it's money or property. Here, the theory is they were creating something to replace the Democratic one and to fool the four recipients into thinking this was the genuine document of the state of Nevada. I mean, if I follow the logic, they were trying to deceive the four recipients, Congress, those who count the electoral votes on January 6th, into believing that this was, the Republicans had won the state of Nevada, and the 6 votes were the object of the deception for the state of Nevada. Is it 6 electoral votes for Nevada? Okay, 6 votes, we just have 6 electors, so I didn't want to misstate it. But that's what the thought was. Here, there cannot be, it's indisputable from the ceremony what the individuals said. I'm talking about December 14th, where they openly, not deceitfully, openly stated their position that they were submitting an alternate slate. You can get that out of the December 9 memo where it lays out, in order to be able to challenge the validity of the election in Nevada, you have to, by December 14th, by federal statute, submit that declaration. Because in the memo and in the case law, if they had not submitted it on December 14th, and then they won litigation prior to January 6th, it would have been meaningless, moot. That has to be submitted by law. That's why it's called an alternate slate. And in the memos, that's why.
Some of them are rabbit hole, but let me ask you a question there. If they won and they didn't vote, there'd be no electors, period? Is that Nevada would not have submitted anything? There would be no congressional ability to go back and say, hey, we're gonna allow some electors, because Nevada's system doesn't allow for any wiggle room. So would you say that there's literally no electors, had they actually won later on some sort of action that might have been filed?
If they won later, the fact they can't, after December 14th, submit that document. It has to be submitted on December 14th.
Okay, and that's,
So
like I
if
said, that's,
they won the litigation,
yeah, that's somewhat of a rabbit hole. Can you jump back to just how you phrased the elements? One, the forged document, that being the alleged certificate in this case. Two, knowledge of forging, signing it. Four, you had intent. The third one, I was thinking about intent, so how did you phrase what you believe the elements are, like your third element?
okay, well, the first one, the estimate itself is forged within the meaning of the statute. Second one is, the defendants know that it is forged document. The third is they utter it. I mean, it's the language of the statute,
Okay. and
which
that's
I
what-
just call passing on.
Right,
And
okay.
then the fourth, on each of those elements has to be done, not with a general intent, but I am doing it to deceive. And not only deceive, but that I acquire something from the person I intend to deceive. And in any case, I mean, theoretically, if they had contrived to intercept the Democratic documents and replace them with their own, to trick the four recipients into going with the Republican vote. But here, there was no intention. The intention was stated right by one alternate and one of the defendants. Where am I? You have Jesse Law, who stated on the video, we want to pull this right back into the courts. You have James Marchant, we're going to be prepared just in case, once this works its way through the courts. Announcing exactly what in the memo, which is Defense Exhibit B, when they were first contacted about saying in contested states you need to put in your votes by December 14th, and here's a press release as to what should be done. Announces an alternate slate, because in case we win the litigation, we're going to have our votes in. And they didn't issue the press release that's in Exhibit B of the defense, but instead they publicly stated it for everyone to hear. No deception whatsoever. To me, the only, I see no evidence of an intent to deceive anyone. And what you have here, what the state is talking about is, was there a false statement on that document? And the false statement was, they're the duly elected and qualified electors of the state of Nevada. The problem is, that is not this criminal offense, which requires a specific intent to deceive. The plain submission of a document with a false statement is a different statute. It was the second count of the indictment they were under in Clark County. In Clark County, they were charged 2 counts. One was submission of a document with a false statement in it to a government agency. That's a general intent crime, and the only element of it was knowingly. I knowingly submit a false statement to a government agency. General intent crime. That was charged in Clark County. Second offense was forgery with the intent to deceive and defraud. When the state's talking about that is an absolutely false statement and they send it on, if that's a crime, it is not this crime. It can be criminalized possibly under other statutes, but not this one. These are not attorneys. These are people who were guided by attorneys. On Exhibit B, if you look and Google Mr. Chesbro on his website and LinkedIn page, the person who reached out to them, and Mr. DeGraffenreid, receiving this, passed it on to Mr. Bunnell, their attorney in the litigation, saying, is this legit? Meaning someone reaching out, saying this with his credentials. And his credentials are he's Mr. Constitutional Scholar from Harvard, and he represented Gore in the Gore.
Your Honor, I'm going to object because this is testimony that's outside what was admitted at the hearing.
Correct.
Okay.
I'm just saying if you Googled it, what I think you'll find.
Sustained, and I can't do that.
But in any event, my point is, they are laymen in a complex area, meaning the electoral college and everything else, are litigating in district court and in the state Supreme Court because they believed there were improprieties in the election which need to be addressed. They were suing for relief on that. And then they're told that in order to continue this litigation, in case we win by January 6th, you have to turn in these papers. And the lawyer sends them the papers and says, Rudy Giuliani and the Trump campaign said, here, I'm a lawyer from Wisconsin and I prepared these and they're all ready for you. And so what do? Not with any intent to deceive anyone. They do what they think they should do to preserve their right to continue to contest the election. I asked Mr. Gross, was there, in those hundreds of emails, was there ever a suggestion by anyone, not only the defendants, anyone, about let's do something secretly and improper and deceive somebody about what we're doing? He answered, there was none. That's all they did. I think Ms. McLetchie will address why this isn't even a forged document. But I can't see, I mean, and of course the idea that we can infer an intent to defraud. I mean, that is a presumption that is permissible. And in the cases where it's used, and even in the Supreme Court case where it came from, it's where you just have someone in possession of a forged document, and there's no other explanation for it. At a preliminary hearing, you can presume they're up to no good. Here, the presumption is easily overcome because there isn't any evidence to support anything other than good faith effort on their part. I had asked, even at the grand jury, in response to the Markham notice, to present an instruction out of NRS 194-0107. No person may be convicted who committed the act charged through misfortune or accident, whenever it appears there is no evil design, intention, or culpable negligence. That epitomizes what happened here when these people, in good faith, did what they thought they were honorably doing, as you can see from the ceremony. And in closing, and allowing my other counsel, I just have to voice more argumentatively and opinion-wise. Speaking for the 6 clients, 23 months.
Hang on a second. Do we have is it being recorded?
It's being recorded to the room, that's correct, the Zoom call just stopped. I'm working on getting the Zoom call back on.
Who's on Zoom, as far as we
I'm
know?
not sure, Judge.
None of the
It
parties
could
are
very well
on Zoom?
be my office, because they watched in case that we needed anything, so I'm not too concerned about it if we can't get it back up.
Okay, I'm not either,
So,
frankly. I mean, we have all parties here, and if it's that important, people will show up, and this was a courtesy.
if he's gonna give opinions about, I'm not exactly sure what the opinion is, but I
Well, it's
I have
argument, is
concerns.
what I'm saying.
Yeah.
Like, my clients have been silent for 23 months, biting their lips out of respect for the court and the system. Never going public, never arguing or complaining about it. And so I like to look at it so that they can hear it from their perspective. This was an open, absolute, known by everyone in the world what they were doing. And on December 14th, they did it. Everyone knew it. No one thought they were 6 people committing felonies on television in front of the legislative building on December 14th. No investigation, no search warrants, nobody accused them of criminal activity. Secretary of State didn't. No one did. Now we learn 15 months later, Attorney General starts an investigation. And then on the 2 weeks before the running of the statute of limitations, we get a Markham notice out of the blue, and they end up getting indicted by the Attorney General's office.
Your Honor,
Of course,
Yes, sir.
I'm just gonna object. This is not argument as to the elements of the crime. This is just fodder to their opinions as to what the process was. I don't think that's relevant to the court's determination. And then
As far as,
commenting on their right to remain silent, I also think is improper. So I asked that part to be stricken.
I don't think it's improper for me to voice in the courtroom.
you brought up the right to remain silent. I am not considering that in any way, shape, or form, simply for the record. And then what happened in the timing of the charges in Vegas, I don't see what they have to do with this particular charge. I'm here for probable cause on this. So if you can move on from that point.
Okay, I'll move on. Case was dismissed in Clark County because it never should have been filed.
Again, Your
there.
Honor, I'm gonna
And
object.
then-
That's not evidence in this case.
Yeah, I'm gonna strike that, and that
Thank
is
you.
not correct. The
And then-
the dismissal was for venue, so move on from these 2 points.
It was filed here on the eve of the statute of limitations. Okay?
Correct.
And coincidentally, I come from a simple background. If it walks like a duck, talks like a duck, it's a duck. And so that's why I draw inferences. And so when I see again on the eve of the statute of limitations, I file it here again in Carson City, and on the same day, coincidentally, the Attorney General
Your Honor,
files for governor.
I'm gonna object.
I'm gonna
This is
sustain
just-
the objections. It's got nothing to do with
Well,
probable cause.
I just, why did I try They've been silent, I'm voicing some of their frustrations. I
You don't
understand
have,
it's
you don't have
not,
that privilege to testify for them. That's their choice, and I'm respecting their choice not to, not holding it against them in any way, shape, or form.
I appreciate that. And my intention is not to improperly influence the court, because I can tell from my experience, you're very judicious and you run a tight ship. And I'm satisfying my clients, let me put it that way.
Okay,
So
so you can do that on your own time.
I understand. Thank you very much, Your Honor.
Okay.
Your Honor, before, can we take a quick break, bathroom break?
Sure.
Like, maybe 5 minutes?
Come back at 10:30?
Thank you, great, thank you.
Thank you.
Somebody else can do it.
She also just lied. I should have given her when she lied.
We got it. Your Honor, I'm going to be, bathroom record?
Yes, ma'am.
Okay. I'm going to be very brief. I know my esteemed colleagues are going to have some additional argument as well. Obviously, I'm here on behalf of Ms. Rice, and I think a lot of positions are the same. And the state talks about slight or marginal evidence, which that doesn't mean just a scintilla of evidence. And I know that this court is very well versed in the law, was a prosecutor for a long time and a judge for a long time. But Sheriff v. Dada, 115 Nevada 175, and in that case, they quote Graves v. Sheriff, and probable cause requires that the evidence be weighed towards guilt. It's not just a scintilla of evidence, and they need this evidence on each and every element of the offense. And when we're talking about forgery, the court is well aware this is a specific intent crime. Whether or not Donald Trump, Rudy Giuliani, even Kenneth Chesbrough, whether or not any of those individuals had any intent otherwise, we need to look at each one of these individuals, and the state has to show this evidence against each individual. The state stated, oh, they were trying to steal an election. No. If the court looks at the entirety of State's Exhibit 2, as well as Defense G, which is the entire raw video, their intent was not to steal an election. They talked about the instances of what they believed was voter fraud and multiple people voting multiple times and different ballots going out to people who didn't exist anymore, things like that. That's what they're talking about, openly. They're trying to not steal an election, they're trying to prevent the stealing of an election. And when you look at the statements, and yes, there's a permissible inference, if it's a forged document, there's a permissible inference. However, there's no actual evidence that there was an intent to defraud. The evidence actually weighs against that. It's not weighed towards guilt, which is what is the requirement under the law. And you look at the statement of Mr. Marchand, who was one of the alternates, who was at the ceremony, and he says, we're going to be prepared just in case, once this works its way through courts or whatever remedies President Trump comes up with or his team. We have Mr. Law stating, we're trying to pull this back into the courts. We have in Exhibit 7, a quote by Mr. DeGraffenreid on the 14th of December. There's still legal action pending in all of these states. So what we're doing here is complying with the requirement to vote on this day in the state capitol in the event court cases are resolved favorably. In their minds, on December 14th, there's still legal challenges happening. So the relevance of it was possible within 90 days to file a cert, they believe there's ongoing court cases, and they made it clear in the video and in their quotes that they believe there's ongoing litigation and we are voting in compliance with the memorandum we received by this attorney, that we have to submit these votes on this day. Were they trying to defraud? Were they trying to forge anything? There's no state seal. There's no Barbara Sagowski signature. And the number one requirement, and we heard this yesterday from Mr. Velosson, the number one requirement is that the Secretary of State must oversee the votes. The ceremony and the statements at the ceremony, that's not what they're charged with. But what those statements show is what their intent was. Their intent was not to defraud anyone. Their intent was to contingently say, these are our votes as the Republican electors. So the state has not shown, by slight or marginal evidence, weighed towards guilt on each and every element of the offense against each and every one of these individuals, or any of them individually. Each one of them has to have that specific intent. They don't have it. With that, I'll see it here. Thank you.
I'm gonna come out to the podium.
Anywhere you like.
Thank you. I can't see as well if I'm not at the podium, so I'll pull up there. It's okay.
No, I couldn't argue sitting down when I was looking at it.
Definitely not. So the state today asked why defendants sent the documents to 4 agencies if they weren't intending to defraud. The state doesn't need to ask that question. As Ms. Levy just explained, there is all the evidence about the defendant's intent here explains just exactly why they did it. They made multiple public statements making clear that they were preserving the right to petition the government to redress their grievances about the elections. I think the court described the issue about whether you need to submit the electoral certificates and what happens if you don't, for example, what happens if you don't have the certificate of ascertainment additionally in Nevada. All of those issues might perhaps be a rabbit hole, and it's a confusing area of law even for me. But the evidence shows that the defendants believed, both on what they received from Mr. Chesbrough and based on their own statements, that they believed that this was a necessary part in bringing challenges and preserving challenges for the election. And to preserve a challenge, incidentally, that does not mean that you need to eventually finally go through the final step in that challenge. The state today, though, ignores all of this, ignores the fact that this conduct was clearly tied to the First Amendment and the right to petition the courts and the right to even be wrong. The United States beyond this, you even have, lying alone isn't even punishable. Here they weren't lying. They truly believed, I didn't, but they truly believed that Donald Trump won the election, and they wanted to, in the words of my client, Mr. Law, they wanted to take that to the courts, and they had every right under the Constitution to do so. The state complained today even about the ceremony and them publicly saying that Donald Trump won the election. But the state is not permitted to punish disagreement with its official determination about the results, even if the state is right, as I think the state was, about who won the election. Forgery, too, is also not just any false statement. It's a particular type of falsity, which I'll get into in a second, and you additionally need evidence of intent to defraud. This isn't a forgery, though, at all. It's the wrong statute. Attorney General Ford publicly said this wasn't a crime, went to the legislator, tried to get
I'm gonna object, that's not part of the record.
Well, we know that the Secretary of State's office didn't think this was a crime. Years later, the Attorney General tries to fit, in my view, a square peg in a round hole. Forgery is the false making of a document that purports to be something other than what it appears. In Winston v. Warden, addressing an issue with a check, 86 Nevada 33, the Nevada Supreme Court explained that signing your own name on a document, a check, while not having sufficient funds is not forgery, because it's still, the document is still not, they're not.
Was that the insufficient funds case, or was
That
that
is
the
an
case
insufficient funds case.
where he didn't have an account there at all, but it was a legit check, so.
It was an insufficient funds case, I believe. But either way, This is what the authority says.
And what's the case name again?
It's a Winston v. Warden 86 Nevada 33. This is what the authority says, and pardon my eyes, but the false making is the making of a writing that falsely purports to be the writing of another. United States v. Price, this is a Ninth Circuit case, 1981. There's not a lot of Nevada case law on the false making angle that I think the state is going through. But in general forgeries, the false making with the intent to defraud of a document which is not what it purports to be, as distinct from a document which is genuine, but nevertheless contains a term or representation known to be false. The distinction is that it's between a document signed by a third person using the signature of another, a forgery, and a document signed by an authorized person, but containing a promise known to be false that does not bear on the authenticity of the instrument. A falsely made instrument is one that is fictitious. That's United States v. Price, 655 F2D 958, Ninth Circuit, 1981. Another Ninth Circuit case, Wright v. United States, 172 F2D 310, Ninth Circuit, 1949. False making has reference to the manner in which the writing is made or executed, rather than to its substance or effect. A falsely made instrument is one that's fictitious, not genuine, or in some material particular, something other than what it purports to be, and without regard to the truth contained therein. These cases make clear that the state wants essentially for you to presume that this both fits within the forgery statute and intent from the mere fact that it contains a false writing. But the certificate was nothing other than what it purported to be. The Nevada GOP electors' own slate of electors. They said that out loud. The court the state asked the court to assume forgery and also assume intent, and to myopically only consider that it contains a false statement and the fact that it was sent to agencies, to imagine that it was both an actual forged document with the intent, and there was an intent to defraud. But notably, in all the time that the state's had to make its case, all that it has is those two things, that Trump didn't want, and that they signed the document and sent it to state agencies. The countervailing evidence that the defendants have presented is much weightier. First of all, the defendants only sent one of the three required documents. They didn't put the state seal on it. They didn't counterfeit anybody else's signature. They, in public, said why they were doing it. No one who's trying to submit these to various agencies, to get the agencies to accidentally accept them as the real state official results of the election, would go on TV and explain exactly what they were doing. They made very clear. Fraudsters don't say out loud what they're doing. The state today, I think, argued that this fits within the statute because they altered what Mr. Chesbrough gave them. Altering, under the meaning of the forgery statute, Your Honor, would be if they took the official state documents, right, and they whited it out or replaced the official results with their results. That would be altering a document. This is not altering a document. In patent, it is true that the state said that you could consider, that you could infer intent to defraud from the fact that somebody had a forged document. But that case, I think, is relevant both on intent and on forgery. In that case, what the defendant had was a money order where they signed somebody else's signature and they tried to use it to buy a United Airlines plane ticket. That's not what we have here. Here we have people who thought that under the complicated interplay between state and federal law, and these are lay people, and I sitting here today in front of you still don't understand it. Mr. Hardy might be able to explain it better than I can. But they were trying to do what they believed. They believed Donald Trump won that election, and they believed that they should do what they needed to do in the courts to challenge that result. They received a memo that's been admitted into evidence from Mr. Chesbrough about why this was necessary and how the state requirements worked regarding electoral certificates. So they tried to do the best they could to preserve the right to petition despite these complicated conflicts between state and federal law. That's exactly what they did. I think the court yesterday was querying why Chesbrough's statements would be relevant here. We have a statement that Chesbrough provided to these defendants when he asked them to do what they then did. So I think it's extremely relevant on their state of mind. And it dovetails exactly with what they said out loud in a public ceremony where they did not break any law by saying that Donald Trump won. And again, as Ms. Levy explained yesterday, this public ceremony was also not designed to trick anyone into thinking this was the official State of Secretary proceeding on the ascertainment of votes. This was a televised public ceremony in which they were expressing their disagreement with the state's official results of the election. The state it was not a lie, they believed that Donald Trump won. Were they incorrect? Yes. Are they entitled to be incorrect? They are. And the state cannot punish that. And all you have in the certificates that they provided is the same statement being sent to different agencies. For what purpose the state asked, they told you. Because as Mr. Law said, we want to take this to the courts. They had every right under the First Amendment to both have that ceremony and to do the collateral steps they believed were necessary to go to the courts and challenge the outcome of that election. The state wants the court, and relying on Patton, which looked at the specific facts of that case. The language in that case doesn't say you can always presume intent where there's a forgery. And again, we don't even have a forgery here. It talked about the facts of the case, that specific case. But here we have that the state wants you just to look at those things, as I mentioned earlier, and to ignore the mountain, frankly, of evidence to the contrary. Their own witnesses talking about the documents being bizarro, not fraudulent, and farcical. And the fact that they didn't submit the other two documents, the fact that they didn't do this in secret and trying to deceive, the fact that they were openly explaining that they disagree with the election. The state may dislike the fact that the defendants disagreed with the outcome of the election, and they may dislike how they did it, but they cannot punish that disagreement. And where all you have is their alternate elector slate being submitted for a purpose that they made clear, that you cannot infer intent to defraud, even if such a document could be fit into the forgery statute, which it also cannot. Thank you, Your Honor.
Thank you very much.
Good morning, Your Honor. Brian Hardy. Again, and I don't want to belabor the point on the fact that this is a specific intent crime. I think we've heard plenty on that. I'm going to try to keep my stuff to where apparently, according to Mr. McLetchie, it appears like I'm the election nerd that gets to talk about elections and how those work. And so I'm going to talk for a brief second about the fact that this is a specific intent crime. And while it's permitted for you to infer intent, you're not required, especially when there's no evidence of it. What happened here, and what the evidence clearly has shown, is that we had individuals that were engaged in an election-related lawsuit, that were in the process of contesting that lawsuit, and they were simply preserving a potential remedy while they awaited the advice of counsel on how to proceed next. That's what occurred here. And if you don't believe me, you can look at the Exhibit B that was admitted before this court, and I want to read specifically portions of that particular email. This comes from Jim Tropis, who's a lawyer, and what he says, he talks about there, is APP 1127 is the date number. He says this: of course there is precedent for such a meeting. Democrat electors pledged to John F. Kennedy, convened in Hawaii in 1960 at the same time as Republicans, even though the governor had certified Richard Nixon as the winner. Much like we had in the state of Nevada. the governor had certified that Joe Biden was the winner. But there was a convention that was held. They met together. The electors did that. And in the end, this is his quote, in the end, the state's electoral votes were awarded to President Kennedy, even though he did not win the state until 11 days after his electors cast their votes. The key thing in that case is they cast their votes. If they hadn't, there would have been no remedy for President Kennedy. They had to do that. And here, in order to preserve a remedy, those attorneys, whether I agree with their strategy or not, has precedent, and it shows the intent of these individuals by following that advice and doing exactly what they did in 1960. They intended to preserve their remedy. The next paragraph of this particular says, the legitimacy and good sense of two sets of electors meeting on December 14th to cast competing votes for president and vice president, with a conflict to be later sorted out by the courts and Congress, was pointed out by prominent Democrat activist Larry Lessing Van Jones in an essay published last month. People acknowledged. Experts in the field of elections acknowledged. This happens in the past. It happens now. We've been talking in the state about, even during general elections, they're what they call provisional ballots, decided by people later.
Your Honor, I'm going to object. The court.
It's just named after the factual presentation. Move on.
In continuing, Mr. Trooper states that given the results and I will substitute Wisconsin for Nevada, but it says given the results in Nevada are still in doubt, and they were. There had been decisions by the Nevada Supreme Court, but there was still contemplation about whether and how these cases, consolidated or otherwise, were going to make it to the United States Supreme Court. And there's been evidence provided, an acknowledgement that 90 days later is how long they had to make that decision to look at the evidence, see whether they could go ahead and pursue that as a revenue. But the Supreme Court needed to have alternative votes to rely upon if it was to overturn that decision. Just as it had done, if they hadn't cast those votes in 1960, there would have been no votes to count.
That's only if Chesebro's theory is correct. We don't know how it would work out when a state under that scenario would literally have nothing to present.
We do know because it happened in 1960 in Hawaii.
Because
We know that because those.
We keep talking about 1960. I haven't really objected, but if the court would like to know, at the time that this all happened, there was a recount. There was 92 votes that separated Nixon and Kennedy. I know it doesn't make a difference, but the recount was still ongoing at the time, so there was still election litigation pending in that state, which hadn't made it final. That's why those votes could be allowed.
as opposed to here.
But here, the election litigation in Nevada had concluded. In Hawaii, it hadn't. There is a distinction.
It was an election contest, Your Honor. There was a recount in that particular one where they were counting votes. There were challenged votes in this particular matter, where they were challenging the votes as well, which would have resulted in one of two things happening as sought under the relief. The relief that was sought as entered in the orders that are before this court were one of two things. Either to throw out certain types of votes in order to be able to modify the count so that it could have gotten down to a margin that would have been prevailing for President Trump, or two, to throw it out altogether and hold a subsequent re-election as necessary. Those were the two items for relief. If either of those had occurred or been granted and there'd been a change, if they hadn't voted before the safe harbor provision that we talked about previously, they couldn't have been counted. That's why this was necessary. I talk about it, Your Honor, specifically as they were preserving a potential legal remedy. We do this all the time. Courts do it all the time in all kinds of cases, where you preserve the legal remedy to give people the opportunity to continue on with their appeal. Again, that was what was in the mind of these individuals. That was their intent. It wasn't to defraud. It wasn't malicious. It was their intent. And that is clear through the statements they made, through the evidence that's been presented. Now, this is a consolidated proceeding, and I do represent Mr. Hindle, and I want to make this point. This is a consolidated proceeding, and they must present evidence of each and every element of the crime, and they must present it against each and every defendant. And so I would submit that not only have they not presented the evidence of each and every crime, but they haven't submitted it with respect to each and every defendant, as there's been a focus on some of the other defendants, in particular Mr. Hindle, and he has some individual rights there as well. Thank you, Your Honor.
Thank you. Mr. Arnold, correct?
Yes, thank you, Your Honor. I just have a couple of brief remarks on behalf of Mr. Meehan. First, I would echo and join the argument presented by my colleagues, Mr. Wright, Ms. Levy, Ms. McLetchie, and Mr. Hardy, all of which I think equally apply to my client, Mr. Meehan. One addition I would make and sort of wrinkle I would add to the conversation, and this is unique to Mr. Meehan, would be, yesterday we heard a lot of testimony from Mr. Rose in particular about emails that he reviewed and subpoenaed and obtained, emails that came from the quote-unquote Google production, some of which have been introduced into evidence before the court. I would respectfully submit that there's a dearth of evidence showing any substantive or material engagement on Mr. Meehan's part with those particular emails, beyond the mere fact that he was a recipient on said emails. So I think keeping that fact in mind, Your Honor, along with the argument on intent that was presented by Ms. Levy and Mr. Wright, I don't think the state has satisfied its burden to present marginal or slight evidence on the fourth element that Mr. Wright articulated regarding intent. So I would submit on that, Your Honor.
Thank you.
Your Honor, on behalf of Mr. DeGraffenreid, we join in with all counsel's statements. With regards to Jim, there's just one little thing that it's been passed over. But what really shows Mr. DeGraffenreid's intent is when he received the contact from, or the email from Cheeseboro, the first thing he did was forward it to the attorney, Manal, that represents the GOP in the state of Nevada, to find out, is this guy for real, and what do we do? That is not the intent to defraud anybody, harm anybody, deceive anybody. That is the intent of a good citizen doing what a good citizen knows who's a layperson, contacts their attorney. Now, if their attorney gave him bad advice, so be it. But he contacted his attorney and said, what do we do? And they were set down this path. And I mean, you've heard this a dozen times now, but you don't get on TV and tell the world what you're getting ready to do and what you do. And say a prayer, and say the Pledge of Allegiance, and sing the national anthem. Makes no sense. I've practiced law 45 years. I've done a lot of white-collar crime, and this is the only time I have ever had a white-collar criminal, alleged white-collar criminal, get on TV, say a prayer, sing the national anthem, and tell the world what he's getting ready to do or what she's getting ready to do. So on that, I'll submit it.
Thank you.
Can I just have like a 5-minute break?
Sure.
Just want to collect my thoughts so that I make it brief. That's
Yes.
okay. Thank you.
Absolutely, no, we got plenty of
I will
time.
not be lengthy, so I think we'll be good with prior to our lunch.
Okay.
Thank you.
About 5 minutes.
Thank you.
Ms. Engler.
Thank you, Your Honor. We're coming to the end, so I'm going to reiterate that I'm going to make it brief. I had forgotten to mention this earlier, and I know the court has indicated that the report by Jack Smith isn't one that the court's going to take too highly into consideration, but I thought it important to note on page 68, it specifically says by Mr. Smith, this report should not be read to allege that any particular person other than Mr. Trump committed a crime, nor should it be read to exonerate any particular person. So I think it's important to note that this was geared specifically towards the conduct of Mr. Trump. I also wanted to clarify that The state of Nevada is not charging the defendants for their beliefs. I agree with the First Amendment. So does the Attorney General. What I'm charging them with, and what the state is charging them with, is uttering a forged instrument. Because whatever their beliefs were, they executed a document that was false and then uttered it. Ms. McLetchie cited to the Price case. And I agree, I cited it in our pleadings in other courts. Forgery is the false making with the intent to defraud of a document which is not what it purports to be. The real certificate of vote for the state of Nevada is made by Mark Voloshin and the members of the Secretary of State's office. So any other document purporting to be the certificate of vote is a forgery. Their document contains false statements. They're entitled to be wrong, but they're not entitled to execute and sign a false and forged document and pass it off to election officials. And every one of them did that. Every defendant signed a document declaring themselves the duly qualified electors for the state of Nevada and then passed those documents. Under NRS 205-110, it makes reference that if you find that they have uttered that they're guilty the same as forgery. And forgery defined is a long list of things if you look to 205-090. Any document or paper recorded or filed in any court with any public officer with the intent to damage or defraud any person, body politic, or corporate, whether the person, body politic, or corporate resides in the state, is forgery. Petitioners were aware at all relevant times that the document that they submitted was not what it purported to be. They knew it to be false. On December 14th, they knowingly, and in a present tense statement, a definite statement, said they were duly qualified electors. And I think the court needs to look at what was put in the document, because that's what the forged instrument is. What is in that writing? The election contest had ended. What happened nationally is of no consequence. They've argued that there is the potential for this other litigation, but their statements in that document were present tense, that they were the duly qualified electors. That's what this court has to look at. Nobody's disputed that they uttered the documents. I think it's clear from Exhibit 7 and the email and then the subsequent USPS records that the documents were sent, that they executed. So I think we're left with the intent. And there's been a lot of conversation about intent. And all of these what ifs. What if this? What if that? That's what we were doing, right? But that's not what the document said. The defendants are individuals. They are of their own mind. They made a conscious decision to execute these ballots, claiming they were the duly qualified electors for the state of Nevada, when in fact, they knew those statements to be false at the time of its making, and they uttered those documents. The state has met its burden of slight or marginal evidence, and the state is asking that this court bind this matter over for trial. Thank you.
Okay. Y'all got a good judge for this hearing from the perspective of being a blank slate. A blank slate not in criminal procedure, criminal law, but on the facts of this case. I say that because I was mulling this over all night last night. Not surprised that the case is cited. Was up late reading through them looking for clues to help me decide this. But why I say that is one of the comments that was made, and I believe it's attributable to Mr. Law on the video, made me think. And it's a comment that was talking about one of the ultimate goals apparently of him and or the group to prevent disenfranchisement, whether it's vote, whether it's confidence in our government. Really made me think, because by and large, I think much of this case boils down to intent. Thinking about the disenfranchisement, I giggled a little because I thought of President Reagan's comment about the 9 most frightening words in our country. Something to the effect of, I'm with the government, I'm here to help. A sad reflection on where we are, but a real reflection. It made me think about my own disenfranchisement. Not disenfranchised enough to not vote, but disenfranchised enough not to even remotely pay attention to any of this before this hearing. Disenfranchised enough to the partisan politics going so extreme on both ends, not knowing what to trust by most of the, like most of the country, frankly. So coming to it with a blank slate, and then for the parties, for good or for bad, you've also got a judge, I hope, that listened, paid attention, and sometimes could be accused of being an overthinker. But I take these things seriously. I like the intellectual arguments. I don't like the histrionics, and both sides thanked me completely. Don't need to do that. I need to acknowledge here, histrionics were very limited, if any. A good read on me, that does nothing but damage credibility at this type of hearing. There's no jury here, so I appreciate that. One additional comment directed solely at the defendants. Some attorneys participated and did more, some did less. That's normal in these cases with multiple defendants. The points have been made, the topics have been covered. You shouldn't have any less confidence in the process because of that. Doesn't cover everything. Maybe there were mistakes made in that process, I don't know, but it was normal. One of the best examples I've ever seen of that was Judge Freeman. We had a 13 defendant murder trial when I was a prosecutor, 1 year on the job. 13 defendants in one room at a prelim, and the only questions he asked were questions specifically pointed out, distancing his client from the other individuals, and that was it. I think he asked like 4 questions on an 8-day prelim. In any event, enough about the setup and me. This is not about me. That is clear. What it also did last night is made me focus on my role as a justice of the peace at a preliminary hearing. Obviously, because we're talking about the burden of proof, the double checks in the system, a preliminary hearing is meant to be a quick and dirty hearing. Basically, is there some substance behind these charges such that it's fair for these people to respond? In the felony world in Nevada, there's not a true arraignment until district court. The parties are not held to even have to say not guilty. So I really honored my role last night and thought about where the preliminary hearing falls in, the amount of evidence that is required. It is often misstated, in my opinion. People say, hey, if there's any slight or marginal evidence, you have to bind over. Slight or marginal goes to the quantity of the evidence, in large part, the volume, the nature of it, but it still must make some theory probable. That's clear from the cases that defense cited. It's clear from, I believe, I'm looking at Sheriff v. Hodes. In Sheriff v. Hodes, they talk about the preliminary hearing. Give me just a moment. Sole function of the court is to determine whether all the evidence received, and they talk about grand jury, but it's the same decision, establishes probable cause to believe an offense has been committed when the defendant's committed it. The finding of probable cause may be but based on slighter marginal evidence, because it does not make, or it does not involve a determination of guilt or innocence of the accused. So I'm not looking at that. It continues, we are not now concerned with the prospect that the evidence presently in the record may by itself be insufficient to sustain a conviction. Accordingly, the state need not produce a quantum of proof required to establish the guilt of the accused beyond reasonable doubt. That goes without saying where we are in this case. They talk about some of the ideas that are at play here, specifically intent, the determination of intent, a person's state of mind at a particular moment as an element of the crime is a subject matter and is therefore seldom susceptible to proof by direct evidence, although the trier of fact is allowed and invariably must resort to inferences from the attendant circumstances in establishing this element of the offense. Then I believe it's also in Hodes. It's in many of the other cases. In that case, there was a shooting, and in that context, they said specifically in the case of Barr to bind over the respondents for trial, the state's not required to negate all inferences which might explain their conduct, but only to present enough evidence to support a reasonable inference that that individual in the case had discharged their revolver with the intent to kill. So the state, and there's many other cases that talk about this, doesn't have to negate every other option. One of the examples I've often heard and talked through with other judges about, argued as a litigator, what if there's two reasonable interpretations? What if there's self-defense? And it's one or the other. Clearly that's an issue for trial in those cases. What if the evidence starts weighing more and more on one side and less on another side? And how does that fit in to the court's decision? At what point is the volume of evidence and the quality of the evidence so great to say that the other side effectively, in this matter, didn't present enough evidence establishing a slighter marginal amount of evidence establishing a belief in a reasonable, prudent person that this is probable. And when we talk about probable, we're not talking about more likely than not. That's the civil standard. We're talking about a standard where people are free to be wrong, just like it was argued here. The defendants were free to be wrong on some underlying beliefs, if I don't know, in fact they were. The officers, the investigators, anyone making an arrest, they're free to be wrong. It's truly much lower, but it still has to be probable. So I was trying to put that in the context of this case and the context of my decision that led me down a couple of rabbit holes that are only analogies, thinking about what happens in cases, how there's checks and balances in the system. There's very little check and balance for a decision that I make today. If I made one not to bind over, clearly the time for statute of limitations in this case is run. In this particular iteration of the case, not the one currently pending in the Supreme Court, likely over. Very, very hard if there's any ability to challenge it. If, on the other hand, I made a decision to bind over, there is a writ to question my decision here, and that's about it, other than moving the case forward. It really made me think about what this is. I've been a prosecutor, a judge, involved my whole career, and it really made me focus on this, and I commend counsel both sides for making me do that and reevaluate things, making me evaluate the disenfranchisement, so to speak. That popped into my head with the example of the beginning and end of the videos that I was shown. I don't know if anyone else in here, when they're talking pledges of allegiance or singing, I had that twinge in me to stand up. So I'm not entirely disenfranchised. And again, this isn't about me. The check and balance, and this is analogous, but not a great analogy. The state is essentially saying, hey, there's a reasonable interpretation, you should let it roll to trial. The defense is saying, no, it's too overwhelming. At a trial, a jury instruction, or the law behind a jury instruction would be, look, no matter how incredible and how weak a defendant's position is, if there's something behind it, they get an instruction in the law on that. So like if there's literally no evidence of self-defense, well, not literally no, but if it's just, everyone would laugh at it. Kind of like the testimony of the individual from the Secretary of State. There's something there, but everyone would laugh at it. The defense in that matter gets that jury instruction, highlighting certain points to it. So I was going through that, trying to go through, in the context of this case, what do the facts mean? In this case, the document, that question in the charging document is the certificate of vote. It's in exhibit, I believe, exhibit 4, for example, there's multiple, that's the one I'm currently looking at is the one that went through the Secretary of State's ceremony. I opened to the wrong page. Anyone can help.
In Exhibit 4, Your Honor, it's State 4213. I don't know if that's what the court is referring to.
Yes. That's the documented issue in this case. Certificate of the votes of the 2020 electors from Nevada. We, the undersigned, being the duly elected and qualified electors for President, Vice President of the United States of America from the state of Nevada, do be hereby certify the following. A, that we convened at the Capitol convened and organized at the Capitol in Carson City, Nevada, 12 noon, 14th day of December, to perform the duties enjoined upon us. That being so assembled, duly organized, we proceeded to vote by ballot, and balloted first for president and then for vice president by distinct ballots, and C, that the following list is all of the votes for president so cast aforesaid. There's obviously more, and it's followed up with the evidence undisputed, the defendant's signatures and the ballots. So that's the document. First question going through the elements, is it forged? One of the other descriptions of a forged document, just trying to put forgery in context, like Ms. McLetchie had done, comes from Bratcher. I don't see the whole title. Let me get to it. Bratcher v. City of Las Vegas. It's a 1997 Supreme Court case, 113 Nevada 502. When they were talking near the end of the opinion about forgery, they said it's an indisputable requirement of forgery that the writing be false. It may have been false in its inception or may have been made so by subsequent tampering with what was originally genuine, but it must be a false writing. Continues in italics. In this connection, it's essential to distinguish between a false instrument and false statements in an instrument. No amount of misstatement of fact and no amount of fraud will make a false instrument out of what purports to be the very instrument to which it is in fact and in law. It's a different way of saying what Ms. McLetchie had said. That document that I just read doesn't have any qualifiers whatsoever, and here we could be getting into the misstatements talked about in that case and the ones Ms. McLetchie brought up, arguing why it's not fraudulent, but it, on the flip side, is intended to be, following the defense's logic, proof that it was true and accurate. I'm fully convinced that that is a question of fact over whether it's forged or not. That's not a super hard call. I really appreciated Ms. McLetchie's going through that in the case law. I frankly looked at all of the forgery statutes last night for context, but that's a question of fact. Minds can differ on that. Moving forward, there's really no issue that it was put out there, sent to the agencies. There might be some arguments for what purpose, but the uttering of it, the putting it out, the real issue in this case comes down to intent in the court's mind, and that's why I did that long lead up to this decision that I'm trying to get to, with what's my role and what's the system right now as it relates to this case, because as to forgery, we have an inference of it. I'm finding for probable cause purposes it's a forged document. They signed it. They're not Nevada's electors. It doesn't say something like we are the Republican electors in case of a legal challenge. We want this to be used later. This is all akin to an objection in court. I get that. If we don't do it, we believe it's lost forever. Whether that's right or wrong, I've frankly got some serious questions in my mind, but that's neither here nor there. So there's the inference. Without the defendant's statements, and it's not all of them, without the statement, I believe it's by Mr. DeGraffenreid, but if I get it wrong, the one that's picked up according to the emails by WP, and it's the one in the, it's at GJ00256, talking about, and this I believe the evidence came out was that same day of the 14th, where he's talking about trying to get back into court. That's some pretty strong evidence of his intent at the time. Without that, without Mr. Law's similar statements, I didn't read the full one in. It's at about 108:55 again of that video ceremony, I believe in the long tape, which is like the G, the long thumb drive. There's that. There's a statement of the co-conspirator that's not present, I'll call it. It's the alternate. His statement. Without those, this would be a no-brainer. You had it, you did it, you sent it off. There's definite questions of fact. to be resolved by a jury. So my issue then is, in light of those statements, if I discounted them, find over no doubt, the inferences are there on an intent to defraud, to trick or deceive. That's a question of fact. I'm not saying that they did that when they mailed it to any of the 3 required places or the Attorney General's office, but that would result in a true question of fact for trial. So I'm down to, I've got those statements in, they are very weighty in the court's mind. What, if anything, is there that would give me pause to say that the state's theory rely in large part upon the nature of the document that it was sent out and the presumption, and I'm not exactly sure it's a presumption, more of a permissible inference, rely on that. So what, if anything, would cause me concern? I was making some notes before we started and then tagging more notes in while arguments were going today. And in that light, to potentially question those statements, did they truly mean what they said? Or were they simply saying those for public purposes and in their hearts and their minds, in what I read from Odes, what was really in there? That's the intent that needs to be decided. So yes, they said it, and I've indicated it carries significant weight with me. But did they really mean it, and is it my decision to take away a trial based on that, to find there's no probable cause? One of the second thoughts I had, were they truly duped, so to speak, as Mr. Smith tends to believe, and it is crystal clear to me that Mr. Smith was aimed at Trump along the way. Reasons to frankly question Mr. Smith's report is, most of us are attorneys in here. Mr. Smith said, essentially, Reagan's quote, "Trust me, I'm going to tell you that co-conspirator 5, I'm not even going to say who he is. Trust me." The question of fact, were they duped, or were they truly intending what they said? And then that's in light of district court has said no, that frankly, under this posture of this state and how the vote was counted, shouldn't have been too much of a surprise. Then the Supreme Court saying no, we're not agreeing with your position. This is 6 days before the 14th. So reasons to doubt. Then, while they may be lay individuals, with what they're saying, if it's taken at face value, at least their representatives were doing this to preserve it. They've got their own attorney to make their own minds up. And then in the Jack Smith report, he said many people told me they wouldn't have done this had they known. But there were also individuals, there was one, I believe it was Pennsylvania, at a bare minimum, it's like, wait a minute, red flags are going off in my mind. So were there any red flags going off in the defendant's minds? The other potential just questions of, do I take their statements at face value and say that they're so overwhelming that I'm precluding a trial? We have that legal inference, and that's all it is in my estimation. Then, what did I sketch here during? Subsequent conduct. It's been asked of me to say, hey, they could have filed within 90 days. That's both ways. They didn't. That's an indication of potential follow through, but it's also an indication they just changed their mind. It's an indication of the realities of this case, the time to do that. It's hard to get a cert prepared for the Supreme Court. There's no doubt about that. It doesn't just happen. But in the facts of this case, nothing was just happening. We had puppet masters, I'll call them, Chesbro or whoever, prepped and ready to go. So, to quote Mr. Wright, if it walks like a duck, talks like a duck, it's probably a duck. Applies to the state's perspective, as well as his perspective, saying take their statements at face value for the truth. The state hasn't done a whole lot, if anything, to question those. See if I have any other final thoughts. So there's, in my mind, more evidence and a fair chunk more evidence on the defense side of the intent to defraud, to trick someone, to deceive them, to overturn the election. That was their goal, as argued by the state, but taking those at face value, their goal was to do it through the legal process. But were there reservations in their mind? Were they doing it for both purposes? Things like that, and a lot of what I brought up, these ideas for we had the state's perspective, we had the defense perspective with some more evidence. I gave that example earlier of multiple theories, and this is clearly not even close to a he said, she said on self-defense. Is that my call? Struggled with it all night. Is it? And the state does not have to disprove, according to the quote I read, they don't have to disprove all the negative inferences or those other matters. The trial, for example, in self-defense, state has the burden to disprove self-defense by beyond a reasonable doubt after it's been brought up. We're at a prelim, we're not a trial. There is an argument that they intended this just by the natural course of what they did. There's a fair amount of evidence the other direction. Hardest call I have had to make in my entire career. I'm going to, by a narrow margin, bind over. I'm going to make that, say that there's those opposing potentials. The issue will be before the district court here, unless this case just doesn't just due to whatever's happening in the Supreme Court matter. And the call will be, because I am doing the gatekeeping of, is there a reasonable theory? Is it probable? Not is it more likely than not? The writ process next, which I have no doubt is coming in district court, that's, do you get a trial? This is that minimal gatekeeping function. That'll be my decision. As far as going forward from here, the clerk informed me, I think she's handing me the same thing yesterday, that the current date's available for an arraignment, and it has to be rescheduled if any. With the district court, I can't change them, or the 27th of this month or 3rd of next month. And then the formal bind over paperwork and formal notice, of that hearing. The clerk would like the ability to simply email it to you all, but for right now, the 27th at 9 a.m. or the 3rd at 9 a.m. And again, all of your schedules can get together with district court, and I believe it's Judge Woodbury's department to move it. I just don't have that authority and availability to move one of those days. I think it probably will be in reality.
On the district court, on that appearance here on that date, do they do that by video here?
I don't believe, no, we have Justice Court clerk. I don't believe so. It's a request to be made to them. I'd frankly be surprised, knowing Judge Woodbury, if he would deny a request like that.
My understanding is it's in person. That's my understanding of this court's practice.
Right, it's in person, the request, on a case like this, trying to gather schedules of 12 people, 14 people at minimum, I would see him likely granting that.
I'll make a record that I wouldn't oppose the state's fine if the court, I know it's not your honor, but the district court.
Okay, so if we can just put something in the record and sending it up, that the state has no objection to Zoom if the defense asks for it.
Your Honor, if we have to set a date, it would have to be October 27th. The court knows I have a jury trial starting that week in November on an invoke setting, so I would not be able to be present on the 3rd.
Someone else could on your behalf or no?
Yeah, in theory, I could have somebody appear for me.
Okay, so, I mean, I get it, this is highly likely to move, but 27th or 3rd, I gotta pick one today.
27.
Okay. Okay, hearing nothing, for now, you're all informed the next date is the 3rd, the 27th of this month, 9 a.m., Department 1. Is this Department 1's courtroom? Okay. I usually sit down the hall in a different specialty courtroom, when I happen to cover here. There was an additional issue that was brought to my attention before this case, and it was to make a record in the criminal system that it exists outside of the court, and that was brought up by the staff. Does there need to be an arrest record, book and release? I'm deciding without hearing from anybody, no. This is a summons, it's like a traffic ticket, it's a citation. If there ever were a conviction on it later, I would order it as a condition of sentencing, but I'm ordering today absolutely not. So if anyone wants to lodge an objection to that, feel free. But that was just brought up by the Justice Court staff wanted to know.
I indicated it was a summons, so I don't have an objection.
Okay. I think that's about it. We have no new additional exhibits admitted. We clarified on that list that AH was admitted. Thank you all again for your time, your professionalism, reading the room with me. It made a difficult case all the more difficult by managing it the way you did. I appreciate it. And that's in a good way, making it difficult, not in the drama way.